as provided in the case of Studi Oscar Kipchumba? I think not. First, by failing to provide adequate information on the true status of the investigations as ordered by the court, I am persuaded that the state has not acted in absolute good faith in seeking to continue to detain the respondents. For instance, the state, despite having been given time to record written statements, has not provided information on the position now subsisting, whether those witnesses have recorded statements or not. Second, the argument that DNA sampling and testing is yet to be done cannot be a tenable reason. As I have stated above, it has not been demonstrated how the respondent will impede that exercise. The state did not respond to the respondent's plea for bonds or bail. I will then dispose of the state's oral application as follows. A. The respondent shall be admitted to a bond of 3 million shillings, with one surety of similar amount, or an alternative of cash bail of 1.5 million shillings. B. The bond bail terms granted in the above shall subsist until the respondent is formally charged and or until investigations are concluded. C. The respondent shall not, before being formally charged, this is important regarding the respondent shall not, before being formally charged or while investigations are ongoing, address, make comments, or discuss in public any matters concerning the events relating to what is now commonly referred to as the Shakahola massacre. D. The respondent shall report to the investigating officer once a week on a day of the week and time of the day to be agreed upon by the prosecution counsel and the defense counsel. And lastly, parties will be at liberty to apply for the closure of this file once investigations are closed. Those are the orders of the court.
Sasa pombe siataweka, tashinda kuweka pombe. Tashinda kuweka pombe.
This is a court of law.
Kama utasikia 3 million. Dunia yako. Pastor Ezekiel's mind after running. Pastor Ezekiel has been after running. Pastor Ezekiel's Bible.
Seeks orders that the respondent to be detained for a further 30 days pending completion of investigations by the police officers who are received of the matter. The counsel for the state have submitted that there are now new developments as autopsies conducted on bodies that were recovered from Shakahola mass graves indicate that some of the victims died of strangulation, and there is also evidence of blunt trauma on others. This report or information urged the prosecution counsel, who was not available in the state at the time the motion dated on the 8th of April was presented, hence the new basis for orders being sought. The state has relied on the affidavit of Mr. George Muriuki ASP sworn today, whose contents in the form of depositions I will summarize as follows. that there have been a substantial change of circumstances that warrant the court to grant custodial orders of the respondent for a fresh period of 30 days to make a total of 37 days. That there is evidence that deaths occurred in the respondent's church as per the OB reports annexed to the deponent's early affidavit in support of the application dated 28th of April. That although the deaths were reported to the police, there was no reason at the time to suspect that the cause of death was criminal in nature, as no autopsies had been conducted on the bodies at the time. That the preliminary investigations have established that the bodies were buried at Chakahola, a site subject to the ongoing investigations. That exhumation of more bodies have been done and autopsies conducted in the same have revealed that the causes of death of some of the victims were not natural but possible homicides. That there is need for DNA sampling and testing to be conducted to ascertain whether any of the bodies exhumed at Chakahola belonged to the people or individuals who are said to have met their demise at New Life Prayer Center. That in the event that the deaths which occurred at New Life Prayer Center are found to be of the persons whose remains have been exhumed from the Chakahola site, murder charges will be preferred against the respondents. That the respondent commands a youth following and is a person of immense influence who is likely to interfere with witnesses. It is on the basis of the foregoing depositions that the state seeks that the respondent be detained for a fresh period of 30 days. The state relied on the decisions of Coleman and Wolfson and Republic versus Diana Suleiman Said and another, and Mukhtar Ibrahim Ali versus Republic, as cited in the case of Mukhtar Ali Republic, and also the decision of Philip Ondara Onyancha and two others, which have had the occasion to peruse and which provide the general jurisprudence that a court is mandated on application by a party to vary the terms of bond or bail in the event of change of circumstances, provided that the relevant facts for reconsideration are provided and are tenable. Counsel appearing for the respondent have resisted the application, urging that what the state is attempting to do is a witch hunt and an attempt to use the court process to curtail the respondent's liberty for as long as possible by claiming that the circumstances have changed to warrant such detention. It is stated that the respondent has cooperated with the police by presenting himself when he was summoned and even recorded a statement under inquiry. The respondent's counsel further state that there are no change of circumstances that have been demonstrated by the state to warrant further detention of the respondent, which will effectively result in the curtailment of his liberty, which is a constitutional right. Learned counsel for the respondent submit that although the investigation to be considered was previously premised on a myriad of criminal offences, there is now no explanation as to why those offences have fizzled out to, resting with the investigating officer zeroing in on the suspected offence or offences of murder, an indication of malice on the part of the investigations. Further, it is argued by the respondent's counsel that the fact that the autopsies have been conducted cannot possibly be construed to be a new matter that would not have been reasonably in the hands of the investigators, as the very purpose of the exhumation of the bodies was naturally expected to be for purposes of determining the causes of death inter alia. It is further submitted that the results of the autopsies therefore were expected and are not a new discovery, and that in any event the results do not affect the matter before these courts, as the deaths have all along been associated with one Paul Mackenzie, his church and his property, his land. In further opposition to the state's application, the respondent's counsel stated that the application for further custodial orders of the respondent do not affect the DNA exercise and that the same can proceed with his liberty intact. The respondent submits further that through his counsel that it has not been demonstrated by the state how his perceived influence over his followers or church members will derail or impede investigations or the manner in which he will interfere with witnesses. The respondent takes the position that no compelling reasons have been preferred by the state to warrant the custodial orders that are now being sought for 30 days, particularly noting that there are no instances of interference or an attempt thereof made that have been demonstrated, and that in any event, the state has been given sufficient time to investigate the matter. The respondent places reliance on the decision of Oscar Sudi Kipchumba and Republic, in which Mbugi J, as he then was, synthesized what is now popularly referred to as the double test. In the decision, it was held that in such pretrial detention applications, the state must first persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred is inevitable due to existing exceptional circumstances. And that secondly, the court observed, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the interest in a potential criminal trial. The state in rejoinder told the court that as the initial application was made under the Prevention of Terrorism Act, POTA, it is available for this court to extend the detention period for a further 30 days, noting that POTA provides for such extension for up to 60 days. It should be 360 days, I'm sorry. 360 days. I have considered the oral application and the responses thereto, and I deduced the issue for determination to be whether the state has presented compelling reasons through the affidavit filed today to warrant this court to detain the respondent for the period sought, that is a further 30 days. I well appreciate the two decisions relied upon by the state, that a court seized of a matter, such as the instant one, may, on application by a party, with demonstration that circumstances have changed, review an earlier position that the court had taken. The question I will then pose is whether the contents of the affidavit presented provide sufficient material that would amount to compelling reasons to warrant the issuance of the orders that the state seeks. In the ruling that this court rendered on the 2nd of May this year, I granted custodial orders for 7 days while observing as follows, I quote, this court will in the premises take it that the time sought is for purposes of recording witness statements, end of quote. In the final orders, I directed that the prosecution today appraises this court on the status of the investigations, and I expected the court to be informed, among others, whether the exercise of recording witness statements is complete, but that has not been the case. It remains therefore unclear to me, in the circumstances, whether the witnesses generally referred to in the affidavit and submissions presented to the court today are the same witnesses in respect of whom, in my view, 7 days was sufficient to have their statements recorded. I say so because the previous application was premised on the ground that witnesses had not recorded statements. It is instructive from the record that the application dated 28th of April 2023 indicated that the respondent was being investigated for offenses under various statutes, which included the offense of radicalization under POTA. In the oral application before me, which in my view is an application independent of the one dated 28th of April 2023, correlated, and from the affidavit filed today, it emerges that the only offense or offenses currently under investigation with regard to the respondent is the offense of murder. In the wake, I do not agree that this is a matter under POTA, for which long incarceration period for a cumulative period of up to 360 days can be sought and granted on consideration. That is so because I will bind the state by the material it has presented before me. That is the affidavit. As to whether the reasons given by the state to meet the compelling reasons that warrant the detention of the respondent for a period of 30 days, I need not restate the progress of processing. It states that the progress of processing the witnesses has not been reported in this court, and it cannot be sufficient to be generally stated under one umbrella that the respondent will interfere with the witnesses in the premises, whereas it was clear that the intention for securing the initial period of 7 days was for purposes of recording their statements as construed by what was presented before me. The state has also provided the reason that DNA sampling and testing of the remains exhumed from the Shakahola scene has not been done. The question that is unanswered, considering that the onus to prove that the compelling reasons are bound remains with the state, is how will the respondent's liberty hamper or impede DNA sampling and testing? The state has not provided an answer to this question. Do the reasons given then in the analyzed position above meet
nimetoka pale Kisii kwa ajili ya pasta wetu. Amefanya maisha yetu yamebarikiwa na tumeonekana kwa watu wa maana. Na vile tulisikia ya kwamba amekamatwa ya kwamba Yesu Bwana wa Mungu akona uwezo na mamlaka. Hata kama dhoruba zikuje, shida zikuje, Mungu anachukua kiwango kingine. Ninaomba katika kupitia kwa hii kama hiyo live mabwana, ninaomba nikaweze kujua ya kwamba mwili wa Yesu sio vipimo vya kimwili pamoja na damu, bali ni Roho Mtakatifu. Kama Mungu ametufungulia, tumebarikiwa na tutaendeleza Injili na itaenda kila kona na wote wanaoishi.
In the case of Studi Oscar Kipchumba, I think not. First, by failing to provide adequate information on the true status of the investigations as ordered by the court, I am persuaded that the state has not acted in absolute good faith in seeking to continue to detain the respondents. For instance, the state, despite having been given time to record written statements, has not provided information on the position now subsisting, whether those witnesses have recorded statements or not. Second, the argument that DNA sampling and testing is yet to be done cannot be a tenable reason. As I have stated above, it has not been demonstrated how the respondent will impede that exercise. The state did not respond to the respondent's plea for bonds or bail. I will then dispose of the state's oral application as follows. A. The respondent shall be admitted to a bond of 3 million shillings, with one surety of similar amount, or an alternative of cash bail of 1.5 million shillings. B. The bond bail terms granted in the above shall subsist until the respondent is formally charged and or until investigations are concluded. C. The respondent shall not, before being formally charged, this is important regarding the respondent shall not, before being formally charged or while investigations are ongoing, address, make comments, or discuss in public any matters concerning the events relating to what is now commonly referred to as the Shakahola massacre. D. The respondent shall report to the investigating officer once a week on a day of the week and time of the day to be agreed upon by the prosecution counsel and the defense counsel. And lastly, parties will be at liberty to apply for the closure of this file once investigations are closed. and other supplements.
Aliachiliwa. Sasa pombe ataweka, atashindwa kuweka pombe. Atashindwa kuweka pombe.
This is a court of law.
Kama utasikiza 3 million. Dunia yako.